Welcome back to the Family Law Channel. An ex-girlfriend of San Francisco's newest sheriff, Flores and Mirkarimi, who will stand trial next month on misdemeanor domestic violence charges stemming from a New Year's Eve dispute with his wife, has told police that Mirkarimi was also abusive toward her when they were dating. My guest is retired Superior Court Judge of California, Eugene Hyman. Welcome back, Judge.
Thank you.
So this is something that happened before. Does this have any bearing on the current case in California?
Probably. The general rule is that evidence of a person's character or character trait is usually inadmissible if offered to prove the person's conduct on a specific occasion. However, there's an exception, two prominent exceptions. One has to do with domestic violence and the other has to do with sexual assault. Mm-hmm. And in a domestic violence case, evidence of a defendant's commission, whether charged or uncharged, whether proven or unproven, of another domestic violence-related offense is admissible to prove that the defendant had the propensity to commit the charged offense, assuming that it's not otherwise inadmissible when the judge does the required weighing under the evidence code. That is, that the that its usefulness is not outweighed by the prejudicial value of the evidence. One of the things that there's certain things that a judge looks to with respect to doing this weighing is the evidence reliable? How old is it? In other words, this is 3 years, which makes it relatively recent. If it were between 5 and 10 years, that would be more of a gray area. Beyond 10 years, I don't think any judge would admit it. The fact that the similarity between the prior bad act, as it were, and the current case, and it will be admissible for purposes of demonstrating propensity to harm the intimate partner, and to show a common scheme in terms of, that he yells and then he hits or something of that, the nature, relevance, and the possible remoteness of the offense, as I talked about, that has to do with the number of years, the similarity of the acts, the likely prejudicial impact, the burden on the defendant in defending against the uncharged act. In this particular case, the prior girlfriend said that she's willing to come forward and to testify, in which case she'll be subject to cross-examination by the defense, in which case then he has the opportunity to cross-examine her. So there has to be this weighing of the probative value versus the undue prejudice. And I think when the weighing is done, probably it's going to be found to be more probative than it is going to be unreasonably prejudicial.
I guess, Judge, one might suspect that the defense might bring up the fact that this new accusation comes from what may be a spurned lover, and she might be prejudiced against the defendant. Well,
that's part of cross-examination. The other thing, and I don't know what the trial judge would do with this particular case, but technically the defense could ask for an opportunity for a proof hearing out of the presence of the jury, where basically the testimony would happen in the cross-examination, and the trial judge would rule whether or not this evidence should be admissible. Now, this usually happens more with expert testimony, where there's a question whether the expertise, the required expertise, is going to be proven. It happens a lot less often with respect to this kind of a case where the defense is saying, well, wait a second, this person's full of it. Well, it's put on in front of the jury, and the defense has an opportunity to cross-examine, in which case the trier of fact is going to decide the credibility of that prior witness or that prior victim of domestic violence.
So in any case, this isn't getting any better for the sheriff, is it?
No, and certainly the trial judge is aware that when you're talking about a prior bad act. Now, let's say hypothetically, as a result of this disclosure by this former girlfriend, 2 more girlfriends come forward and say, he did the same thing to me, and he would yell, and then he grabbed my arm and he left a bruise on my arm. Then the trial judge is going to say, this is piling on, and there's no way that this guy can get a fair trial based upon 2 or 3 prior bad acts for which they weren't criminally proven.
Mm-hmm.
It's alleged by prior girlfriends that these things happened, and that's a different story. That's when the prejudicial value is going to outweigh the probative value, in my opinion, and the average trial judges wouldn't let hypothetically all 3 of these circumstances in if that were to be the case. But when you have one, and this person came forward on their own, then part of cross-examination is going to be, well, gee, this happened, why didn't you say something?
Right.
Or did you say something to anyone? Well, in which case I was too embarrassed.
Right.
The relationship was ending. This wasn't going to happen to me again. I wasn't going to see him again. Don't have anything in common. Like a child, there's no reason to have anything to do with him in the future.
Mm-hmm.
I decided just to let bygones be bygones. And then the jury can weigh it and make their own decision whether she's credible or not.
Well, in closing, let's talk about the protective order. The trial's now set for February 24th, a full month away. Has there been any movement on whether or not a lot of time between now and the trial date would allow him to see his family? Well,
that issue is going to probably be raised on January 30th when the court has set some kind of an evidentiary hearing. And there's also a pre-trial that's set for early February. So every time that the matter is in front of the judge, I'm assuming that the defense is going to request that the protection order be modified from no contact to peaceful contact. The trial judge has other leeway in terms of, let's say that the trial judge doesn't feel, or that the judge that the matter is in front of doesn't feel comfortable changing the order from no contact to peaceful contact. She could allow a visitation supervised or a supervised exchanged or something like that. Could say, look, I want him to have contact with the son, but I don't think it's a good idea for him to have contact with the alleged victim. And she could craft all kinds of orders.
Right.
Whether that's going to be done or not, I don't know, but that certainly is within the purview and within the judge's discretion and legally in terms of something that could happen.
All right. Well, Judge Hyman, thank you so much.
Thank you.
You're watching the Family Law Channel, a production here on the Legal Broadcast Network.